to our Meeting of the Moment program this afternoon. We at the Bar Association are so grateful that you have joined us for our Meeting of the Moment program, focus on education and disability rights. As with our other Meeting the Moment programs, we again are beyond thrilled with the turnout for the program that we have today. Over 180 people have registered and are either in the room or virtually. So welcome to you in the room, and thank you to those on video virtually. I really want to thank the Philadelphia community for showing up for these important conversations. I love always starting with this, so forgive me if you've been to our other programs. But since 1802, that means we are the oldest bar association in the country. Since 1802, the Philadelphia Bar Association has upheld the values of protecting the rule of law and defending our democracy. Our Meeting the Moment series of programming really helps lift up these values. As we continue to move through 2025, we are finding the power of our voice to stay true to our mission, to serve the profession and the public by promoting justice, professional excellence, and respect for the rule of law. We are doing this by trying to create opportunities like this one for lawyers and the legal profession to work together and meet this moment in service to our democracy. It is critical at this time when our justice system is being challenged left and right that we all join together to protect access to justice. In doing so, we will support the mission of the Philadelphia Bar Association, and I'm sure each of your values as lawyers and the legal profession by fostering the understanding of, involvement in, and equal, unabridged access to our justice system. So, we've come up with 3 ways you can lean on our Bar Association at this time. First, to be the convener. One of the Bar Association's greatest strengths is that it encompasses legal professionals from across the city, including different practice areas, firm sizes, and experience levels. We value the contribution and viewpoints that every member brings to the table, and we are committed to creating those tables where we can all convene and support each other, our clients, and the profession. And so, join us. If there's a topic you want to discuss, we will create the table. Second, to be the communicator. We make our voices heard through resolutions, statements, and even amicus briefs. We have spoken out on numerous occasions this year in the defense of the rule of law and the independence of the legal profession. We have signed on to 4 amicus briefs in protection of legal independence, 3 of which, as of today or yesterday, have already provided relief to the law firm plaintiffs, and we are proud to be part of this work. We've also created a page on the association's website that aggregates know the law documents, so please go to our website and look for that information. And finally, to be the collaborator. We will coordinate with different partners in disseminating useful information, promoting opportunities to engage in volunteer or pro bono work, or to donate financially to the work that is happening. So think of the organizations that you're hearing from today that you can donate to. So with that, welcome to the 4th in our series of Meeting the Moment in 2025, this one focused on education and disability rights. As a proud product of the Philadelphia public school system, I am dismayed by the attacks on both our educational system and the rights for the disabled experiencing at this time from our executive branch. I am hopeful that the dialogue today will help us with guidance on what lawyers can do to meet this moment and help make a difference. We have 2 great panels for you, one on the impacts of federal actions on students in Pennsylvania and what's at stake, and the second on the effect of federal actions on students with disabilities in Pennsylvania. Before we begin the programming, I'd like to thank our organizers today, Deborah Gordon-Clare, Darlene Martin, Ann Armistead, Melissa Mazer, Steve Loney, Brent Landau, Debbie Gross, Vic Patel, Harvey Hurdle, Rachel Kipp, and Allie Hooven, with the support of the chairs of the Delivery of Legal Services Committee and the Task Force of Civil Gideon. And a huge shout out to Harvey and Rachel to make sure that the space was set for this program today. And Wes Terry, thank you, Wes, for making sure that we were all set. Hopefully you can see the wonderful work that's happening next door that'll make this space even more beautiful in the future. I'd also like to thank all of our speakers for whom you'll meet shortly. But before we get there, please welcome to the stage our keynote speaker, Adam Schott, Associate Secretary for Student Support in the Delaware Department of Education. And prior to that, Acting Assistant Secretary, Office of Elementary and Secondary Education at the U.S. Department of Education. Adam Schott has dedicated his career to serving students by strengthening schools with an emphasis on those in our region. A leader in the Pennsylvania Department of Education and on the Pennsylvania State Board of Education, Adam served most recently as the Principal Deputy Assistant Secretary at the U.S. Department of Education, overseeing pre-K to 12 programs, federal funding initiatives, and policy development. He played a key role in implementing American Rescue Plan's $122 billion education relief fund and worked closely with state education leaders on accountability and school improvement. Having attended the schools, I'm really grateful for that. Before entering government service, Adam led critical research projects on education finance, school reopening strategies, and charter school improvement for Research for Action. He has also served as a school board member of the Lancaster School District. He holds a Master's of Education in Education Policy and Management from Harvard University and a Bachelor of Science in Secondary Education from Pennsylvania State University. We are, had to say that for my nieces, Adam. Please join me in welcoming Adam to our backstage. Thank you again.
Good afternoon. Can you hear me okay? So thanks to the Chancellor and to the Philadelphia Bar Association, also thanks to the Education Law Center and everyone who helped bring us together today. Lawyers working in the public interest have been among the most effective actors in raising awareness and mitigating damage over the past 5 months, and you've obviously played a critical role in plenty of policy debates before that. So thank you for your advocacy, for your expertise, and for your courage. I'm going to try to do 3 things in my opening remarks. First, the new administration's actions relative to education specifically have been by design overwhelming. So I'm going to try to organize those actions into a couple of key areas: data and evidence, monitoring, and funding. I would also just note at the outset that there's also plenty of culture war stuff, and I see that as cross-cutting across those 3 themes. As I walk through those areas, I'll highlight impacts that may be especially relevant for your work and the work of K-12 education leaders at both the state and local levels. Finally, Philly's blessed with corporate and government and philanthropic and post-secondary leaders, all of whom should feel an economic and educational and moral imperative to stand in the gap for children and families right now. So for each of the topics that I touch on, I'll offer a couple suggestions for doing that. People took my homework assignments much more seriously when I actually worked at the U.S. Department of Education. So, but I'll try. I want to start by asserting, and you can take this from somebody who did federal-facing work at the state level for a long time and then state-facing work federally. The U.S. Department of Education has long been woefully understaffed and under-resourced, considering the level of need that our kids exhibit. As last week's preliminary injunction blocking the executive order to dismantle the U.S. Department of Education noted, indeed, prior to the reductions in force, the department was already struggling to meet its goals. Like, how could it not? We've crawled through the most significant public health crisis in a century, the overnight shuttering of virtually every public and non-public school in the country, historic declines in student achievement, and unprecedented increases in student mental health needs. And while the department's mandate is narrow, it has a critical role to play in supporting states and communities in confronting each of these challenges, including specific responsibilities on behalf of historically underserved students, kids living in poverty or experiencing homelessness, students with disabilities, students involved in foster care or in the juvenile justice system. We know certain kids have experienced more hardship in the forms of historic inequities, barriers to learning, additional learning needs, the differential effects of the pandemic. We know all those things in part because there's been a decades-long bipartisan consensus around collecting basic data on student outcomes and learning conditions, and on the fundamental agreement enshrined in law that to receive crucial federal funds to serve high-need students, states have to show a plan for continuous improvement in their systems. So I don't need to walk through all the ways in which good data matter for advocacy in the courtroom or before a policymaker, but I cannot think of a better example than the work that the Ed Law Center and the Public Interest Law Center did using Pennsylvania's federal accountability plan to secure long overdue changes in how Pennsylvania funds its public schools. What I do want to identify is why dismantling these data systems and terminating nearly every staff person at the U.S. Department of Education who helped maintain them, why that is among the most corrosive actions that we've seen over the past 5 months. To begin, federal data collections like the Civil Rights Data Collection or EdFacts, which is designed to promote the use of high-quality data in pre-K through 12 programming. Also, the multi-year collection around how states have invested $200 billion in COVID relief funding, also dismantled. As these data systems are being attacked or pulled down, there's real risk of spillover into the quality of data collection at the state level. If the federal government stops collecting something, states will probably follow their lead, not because states are averse to transparency, but because state educational agencies like the U.S. Department of Education are threadbare. And it'll be hard for them to justify the use of limited funds to do non-mandated work. This is an especially tall order because education leaders who understand data quality and are the best advocates for data quality, they know that a single year of interruption in these data systems, as we saw during COVID with student achievement data, it can render all of the subsequent collections far less comparable, useful, and valid. So while last week's preliminary injunction is great news, and we're not sure yet how it'll shake out, even the immediate return of most of the department staff who were terminated won't resurrect some of these data systems that were canceled virtually overnight without opportunity for stakeholder engagement or interrogation. It will not address the abrogation of contracts that helped ensure that data collections that still are online are accurate for purposes of generating billions of dollars in annual formula funding. It won't address grants and contracts for research evaluating the effectiveness of things like literacy and math interventions. It won't restore regional education labs, a key technical assistance service for state and local leaders operated by the department's independent scientific arm. As an example of the vital work that RELs do, in 2020, when reopening Pennsylvania's schools seemed absolutely impossible, then State Secretary of Education Pedro Rivera went to the Mid-Atlantic REL and commissioned a study that used machine learning to generate millions of simulations about how students and teachers and cafeteria workers and school bus drivers might be configured around actual school facilities and how those configurations might mitigate the spread of the virus. It was life-saving and groundbreaking work, and it is impossible for me to imagine that type of work occurring out of the U.S. Department of Education today. So that's the bad news. Education leaders who care about data and who care about evidence, who want to know what works and for what kids, have experienced a horrible setback. The good news is that Pennsylvania's institutions, Pennsylvania's and Philadelphia's institutions of higher education, and I know that they are feeling under threat too, they can play a vital role in responding. They can work with states and districts to map existing data collections that respond to federal requirements and create data flows that show how those collections relate to state and local reporting. They can offer technical assistance to keep those collections going, and they can ensure that the underlying data are usable. Everybody wins here. State leaders have new colleagues who can mitigate very real capacity constraints, and local leaders get new and actionable information. Education scholars also ensure that the lifeblood of their research keeps flowing. A final note on federal education data collection and reporting, which will segue Into the second topic, monitoring of programs. The data sources I just discussed, they matter for state and local programming. They matter for educational researchers. They matter for attorneys and for advocates, but they also matter for staff, the remaining staff at the US Department of Education, because they provide a basis for triaging extremely limited staff to maximize oversight of core programs. Let's take the requirements around Title I, Part A, Education for the Disadvantaged, the largest recurring federal investment in America's schools. Even before the staff cuts of the past few months, there were fewer than 24 staff managing the annual flow of $18 billion and the corresponding state plans across 50 states, Puerto Rico, Washington, D.C., and the Bureau of Indian Education, as well as 12,000 local recipients of Title I funds, plus thousands more non-public schools that get equitable services out of Title I. Given those staffing levels, there was no way to monitor all states or even a sliver of school districts on all Title I requirements. So under the Biden-Harris administration, we leveraged existing data collections, existing data quality, to make the best possible determinations about where and how to focus these staff around the states and systems that seemed most likely to struggle in fulfilling program aims and the statutory requirements, including in both the ESEA and IDEA, that were most susceptible to noncompliance. So when states failed to publish their state report cards, we followed up with detailed protocols. Hey, what's going on? We called again. We tried to understand what the limitations were for that state. When the same report cards that provide vital information for parents and families were incomplete, we set up new training to round them out. When individual states reported high rates of students taking alternate assessments, we made difficult decisions to place conditions on Title I awards. Looking at the spread of the data, we realized that there was no state that was performing as poorly on this count as Pennsylvania, and so we made the state high-risk grantee, subject to more intensive monitoring. Under Secretary Cardona and Deputy Secretary Martin, the Biden-Harris administration used data objectively and transparently as a flashlight, not a hammer, to monitor more states on more ESEA and IDEA requirements more exhaustively than any prior administration. Considering the current administration's posture with respect to data quality and staffing and a frankly antagonistic relationship with states, I'm concerned that we're going to see monitoring activities become less frequent, less intensive, and less useful. And like utility is the point. Every state education chief who I had the pleasure to work with over 2.5 years of federal service thought that monitoring was an opportunity for continuous improvement. It was a way to figure out how to sharpen their programs, learn from colleagues in another state, and ultimately provide taxpayers with the receipts to demonstrate that public investments in public schools matter. The new administration is taking a very different approach to monitoring. On one hand, the new administration says it wants to provide states with more flexibility to, quote, return education to the states when it is overwhelmingly a state function. It's also attempting to make states and thousands of local education systems make certifications about how they design their curriculum and institute teaching methods. Can you teach a lesson on the Underground Railroad or internment camps during World War II? Can you partner with your local HBCU to recruit additional teachers to your district so that your students see an educator workforce that resembles the student enrollment? Paradoxically, the administration says it champions states' rights, but it is also flexing new and considerable federal control. The result is that states and districts are generally unsure whether the current leadership of the Department of Education sees these types of programs as unlawful or impermissible. Here's another contradiction. Making states jump through new hoops to provide individual receipts for getting reimbursed for glue and copy paper purchased with COVID relief funds, while simultaneously inviting waiver requests that would allow states to consolidate hundreds of millions of dollars in formula grants, including funds designed to meet the specific needs of students experiencing homelessness, learning English, into giant block grants. The contradiction is intentional because confusion is the point. When states and local educational agencies are understandably unsure and uneasy about how their work will be assessed and on what basis, your expertise and your advice can make an enormous difference. I would encourage the legal community to think about taking some of our guidance and dear colleague letters that are likely to be rescinded and to develop fact sheets and how-to guides that can help states and LEAs that want to do the right thing keep going. I'd urge you to draft sample subgrant assurances and model MOUs that SEAs and districts can use to safeguard themselves from audit findings. Crucially, and it is like the least sexy topic in the world, advocate for responsible levels of staffing at the State Department of Education. If USDE is not monitoring, or they're monitoring in a haphazard or opaque way, state educational agencies are the only backstop for ensuring that students' civil rights are consistently protected and enforced. Speaking of resources, I want to touch briefly on funding, which I see as the third category of harm from the past 5 months. I think virtually everyone in this room has been an advocate for more adequate and equitable education funding. And so, that funding can't be either one of those things when it's totally unpredictable. And right now, federal investments in education are in doubt in every possible way. Take discretionary grants. Hundreds of existing awards have been shredded, with reductions impacting states and communities, technical assistance centers that parents and families relied on, nonprofits, higher education institutions, and more. I think one of the most cruel reductions was the cancellation of $1 billion in grants awarded to schools and higher education institutions in nearly every state to address student mental health needs and prevent future school shootings. These funds were set to prepare an additional 14,000 mental health clinicians to work with kids experiencing crisis. They were also, importantly, a tribute enacted in a rare moment of bipartisan agreement to respond to the killing of 19 elementary school children and 2 teachers in Uvalde, Texas. Current administration justified these cuts by saying that they reflected the deeply flawed priorities of the Biden administration. I want to be clear, the priorities reflected the intent of Congress, with implementation guidance that was crafted in concert with parents, including parents who lost a son or daughter in a school shooting, crafted in concert with parents, mental health professionals, school leaders, child advocates, and crucially, state education officials in rural and remote states that have experienced particular shortages of mental health clinicians. The funds were awarded competitively, meaning that states and communities invested their own limited resources to craft the proposals, and then independent peer review panels scored them based on publicly available criteria. So while there are concrete and important steps that education advocates can take to fill in the gaps around data quality and monitoring, I think it's much harder to contemplate how to address deep and unexpected funding reductions like these. That's to say nothing about the massive $12 billion cut to education funding that the administration has proposed under its FY26 budget. I know all of you have been champions for needed reform of Pennsylvania's state school funding system, and that you'll continue to fight for additional state investments for historically under-resourced schools, for improvements in aging school facilities, and for working conditions that educators deserve. I would also urge you to work closely with school district officials in your communities to highlight the tremendous and specific benefit of federal education funding, and to clearly describe the impact of various proposals to eliminate or repurpose those funds. It should be worrying to everyone that with the start of the new school year just 2 months away, no state has yet to receive any preliminary allocation for core programs like Titles 2, 3, or 4. In addition to using your voice and your expertise to champion responsible funding levels and administration of recurring formula programs, I would also urge Philadelphia's terrific philanthropic community to consider their grant making in relation to the discretionary grants that have been targeted by the cancellations and the cuts of the past 5 months. Countless state and local funders have supported initiatives related to expanding early childhood programs, effective use of data and evidence and program design, growing and diversifying the educator workforce, and providing mental and behavioral health care services at school where kids are 6 times more likely to access them. I think there is a really powerful argument that right now the philanthropic community should focus their efforts on sustaining active and proven programs that have been targeted as the best way to drive systemic change. This is the first chance I've had to reflect on my time at USDE since leaving on January 20th. It was meaningful to me to be able to do it here in Philadelphia. I'm happy to take a couple questions. I also know that I went way over. I would just urge all of you to stay awake, stay in the fight. I'm optimistic that there is a public awakening coming, and hopefully we will all be in a position to ride that wave together. Thank you.
At this time. Otherwise, we can certainly, we can make our.
Yes, I'll stay for the program.
Okay, but thanks to Adam for staying with the program as well. Adam, thank you so much for sharing your thoughts. Really appreciated the ending too. We are grateful that you are here with us to share your thoughts since leaving the position. I would like to welcome to the stage our first panel. I will leave it to the wonderful panel moderator of the first panel, Deborah Gordon-Clare, Executive Director of the Education Law Center, to introduce her panelists. Wherever.
They kept reporting back and forth.
Oh.
I don't have a preference.
Like, do you want to start or go back? I'll start too. And I'm going to start with them just in terms of questions. We'll be with you in 14 seconds.
Oh, I can start.
Okay. Thanks everyone. Afternoon. I'm Deborah Gordon-Clare. I'm the Executive Director of the Education Law Center of Pennsylvania. And joining me today is Harold Jordan, the Nationwide Education Equity Coordinator of the ACLU of Pennsylvania. Michael Athy, the former senior attorney at the U.S. Department of Education, Office of Civil Rights here in Philadelphia, when we used to have an office here in Philadelphia. And Dan Urevick-Ackelsberg, senior attorney at the Public Interest Law Center. And we're excited to talk with you today. We'll try not to be too depressing as we talk about the state of education today and the impact of federal actions here in Pennsylvania. Unfortunately, since January 20th, we have seen the decimation of the U.S. Department of Education, impacting the Office of Civil Rights as well as the rest of the department, as you heard from Adam. You heard a bit from Adam about the impact of the lack of data collection, lack of monitoring compliance with laws, and the threatened cuts to funding, for example. From vitriolic executive orders to threatening dear colleague letters, the federal administration has made it clear that the traditional role of the department to, for example, uphold the civil rights of students in schools across the United States is in jeopardy. And we, along with many of you today, are navigating what we can do as advocates who aim to uphold the civil rights of students. I think it's critical to say, and I assume you'll hear this from my panelists as well, that much of what has been done at the federal level has been challenged in court and struck down as illegal, because in fact, an executive order doesn't trump actual federal law. For example, multiple federal statutes prohibit the U.S. Department of Education from, quote, exercising any direction, supervision, or control over the curriculum, program of instruction, administration, or personnel of any educational institution, or over the selection of content of library resources, textbooks, or other instructional materials. But that said, here we are, and as Adam said, contradiction is the point. So with that, I'm going to turn to the experts that I'm happy to have with me. And first, Mike, I'm wondering if you could tell the audience a little bit about what is the Office of Civil Rights supposed to do, and like maybe the types of cases you worked on. Maybe give an example of a case that you and your colleagues investigated.
Thank you. So I never promised not to be depressing, just so you know. I know you said we would try. I'm dealing with a little bit of some asthma complications, so bear with me if I have some trouble speaking. First, I see Elizabeth and I see Beth. Is there anyone else here who worked at OCR? I just want to recognize you both and thank you for your service. And apologies if I don't adequately express what has happened at OCR because so much. As many of you know, there were 12 regional offices that covered all 50 states, and they shut down 7 of those offices wholesale. It wasn't about, are these the lower performing offices? It wasn't, well, these are the states where we barely get any cases. It was it's unclear why they picked those 7 offices, but those 7 offices had thousands and thousands of cases. And those offices had hundreds and hundreds of staff, people who dedicated their lives to trying to ensure that students just got a fair shake at education. Some of those people were like Beth, who had been there for several years, and some were like Elizabeth, who was starting her career with a deep, deep passion for this work. And all of their cases just went like this. Uh, and sure, they've been reassigned, maybe, but they've been reassigned to those 5 other offices where uh, staff, I'll call it casual cruelty, where staff felt as though they were consistently under attack. They were not valued, and it became clear that enforcing civil rights was no longer the point of the Office for Civil Rights. So you saw a lot of staff voluntarily left. A lot of staff resigned, retired, but I can tell you now that none of it was voluntary. So that's just I'll try to, I don't know how to make it less depressing, but I'm going to try to make it less depressing as I go towards the what is happening currently. You still have a lot of dedicated attorneys and staff that are trying to do the work, but unfortunately, uh, those thousands of cases went to people who were already understaffed at the Office for Civil Rights. And those cases span Title VI, Title IX, but the bread and butter, a lot of what OCR did was disability focused. And those cases range from restraint and seclusion. So you had cases that may be systemic, where you had whole districts that were improperly putting students in different rooms or disciplining them in ways that were inappropriate according to their IEP or their behavioral assessments or their BIPs. Or you just had single cases of restraint and exclusion, where you had one mother saying, "This one teacher keeps putting my son in a different room every day." And it's clear that this teacher does not like teaching students who may have disabilities or students who may have behavior problems. That case, I'm not sure it has an attorney right now. You have simple FAPE cases. And of course, as we know, none of these are simple FAPE cases because they involve students who only get one shot at school. But
Mike, say what FAPE is.
sorry, FAPE is a free and appropriate public education. So, yeah, okay. Um, for example, you may have a parent who their son just wants to do extracurricular activities, but those activities require a certain GPA. And in order to get that GPA, you have to get certain grades, right? But these students have individualized education programs that help them get those grades. So if you have a school that's not implementing that IEP, student won't get the grades, and now the student can't participate in those extracurricular activities. That's just a small example. You have, and I'm sorry, I'm speaking way too long for someone with. I know you're like, didn't this guy say he had asthma? And now he just is going on and on and on. And I want to give respect to my other panelists because I can keep going on and on about what's happening. But that's a small glimpse of what is happening currently. Basically, understaffed, and uh, you have hundreds of cases, and it's indiscriminatory. You may have cases that are systemic. You may have cases where it's one student. People don't have the time to investigate and look into all these cases. They just simply don't. And there's a focus on dismissing cases because people also don't want to lose their jobs, and it's a numbers. There's a whole aspect of numbers when it comes to keeping your job at OCR. I will not get into that at this moment. I will pass it off back to you, Deborah, and let my colleagues.
Thanks so much. Harold, we've all read in the newspaper, and some of us in a more intimate way have seen the executive orders that are attacking DEIA, transgender students, disparate impact, school discipline, Tell us what we need to know about these orders, and what's at stake.
Well, my version of doom scrolling is to see is to see what appears every day on the Department of Ed website, and
Or what has disappeared from the Department of Ed.
well, both actually. What has appeared and disappeared on the appearance front. Uh, I mean, the press releases that come out of the department don't read like they're written by adult professionals. You know, one can hold a different view or a more conservative view of one issue or not, but they were like hoaxes and things like that, terms that you just don't see. But they do give you some kind of clue as to the approach that's being taken. I'd say a couple of things. I think what's happening in ed is a reflection of a government-wide problem. So, for example, if you're concerned about how the ed department deals with students with disabilities, you could flip over to the Justice Department and see the action that's been taken there with rescinding a bunch of the ADA guidance because they consider them to be too burdensome on employers or no guidance for employers. And you find that in the Department of Energy, you find that in almost every department. So it's a fundamentally different view of civil rights. That to the extent to which there are civil rights, there are self-enforcing unless they fit the political priorities of the current administration, which are in a couple of different areas. It's an attempt to make equity into a bad word. And if you look at the history of federal education law, almost to a law, if you look at the alphabet soup of federal laws, they all address equity in some way or another. All of them, from IDEA to the Civil Rights Act to any number of federal education laws, all address issues of equity. And they recognize that different students have different needs. But the point of education is to address the needs of students and to be fair about how to do that. And so my concern is about what happens in the legal arena, but my concern is also about what attempts to influence sort of public opinion, including opinion of people who have the opinions of people who have to make decisions about how to run their institutions. And so we fight against that as well. Education Week, the publication, estimates that there's some 37 lawsuits that address in some way public education, the Department of Education's actions. There have been decisions only in a handful of them, and the ACLU was involved in one of them. We've represented the National Education Association and the Center for Black Educator Development, and one specifically about the EOs on DEI and the demand that local and state education agencies certify that. And we actually won on the first level while the case goes forward. So we actually got an injunction saying that they can't enforce those things with the DEI portal and the certification requirements, et cetera. And so that's a challenge that has been met. But these things are going to continue. And I fear what may happen on the local and the state levels, depending on where you live, with the misinformation that's being put out and the way that it's, the discussion of race discrimination, for example, is a discussion about now in the Department of Ed is about looking for instances of discrimination against white children. That's basically how it is defined right now. And we can expect more of this to come. On April 23rd, there were two White House EOs issued that are relevant to today's discussion. One is about the use of disparate impact analysis in looking for determining whether there's discrimination. And again, that's a government-wide sort of edict or mandate. And then the second is about a school discipline. And we're expecting any day, once again, I'm constantly doom scrolling for this. We're expecting any day from the Department of Ed in cooperation with the Department of Justice, a new school discipline guidance that essentially rewrites the history of the Department of Ed and the Department of Justice's investigations of school discipline. Um, and and it's not going to be something that makes schools safer. Uh,
For students.
Our students safer, or school community safer. But just to show you how bizarre some of the language and the formulations are, the EO on school discipline had a definition of behavior modification techniques, which they say should be prohibited. Behavior modification techniques are any school discipline policies or practices that incorporate or are based on discriminatory equity ideology. That's their definition of behavior modification techniques. And so we can expect to see the Department of Ed send to all the local education and state education agencies in the country some form of guidance. And then the next step is that the Attorney General is supposed to be coordinating with AGs around the country to push some of the provisions of the guidance. And so that's the next shoe to drop. Some of us in Philadelphia, it's how I know Deborah, is we work to eliminate zero tolerance going back 20 years.
Just a few.
Something like that.
Very young.
Yes.
20.
But that's how we know each other. And so, you know, again, it's not just about what happens in the courtroom. It's about the attempt to influence both public opinion, but the opinions of people who have to make decisions about schools. And that's where, in our federated system of education, we need to sort of push back to explain schools are about equity. That's what federal law requires. Laws have not changed.
Thanks. We'll talk a little bit more about the laws that have not changed, I think, and what actually schools do need to follow, both federal law and state law, irrespective, again, of these executive orders. But I want to get into the funding of it all, and Adam touched upon this, and what does it mean for schools in Pennsylvania? What does it mean for Philadelphia with all of these federal funding cuts that are threatened? Usually you see Dan talking with us about state funding, but for today, Dan, tell us what's at stake in terms of the federal funding, and what we can expect to see or not see in terms of what's coming from the feds to the school districts and the states.
Sure. And thanks for having me. Thank you to the Chancellor for your leadership in this crazy moment, and thank you to the various folks we have here from our refugees from the United States Department of Education. You know, I think part of what makes America America is people actually willing to do good, and I think that's what is so awful about all this dismantling. It's just going after the people that are actually trying to make a difference in their community. To understand the impact of attacks on federal funding, I think it's useful just for 30 seconds to talk about the state context. So my office, at the Public Interest Law Center, along with the Education Law Center, Deborah's office, and Melvin E. Myers, we brought and won this school funding litigation under our state constitution. In response to that decision last year, we won. In response to that decision last year, the state passed a law which calculated that schools were underfunded in the Commonwealth by $4.5 billion. The school district of Philadelphia's number was about $1.25 billion. That's looking at whatever a school district has, whether it's from the feds, from their local taxpayers, from the state, and what they would now need in addition. So we're short, according to the Commonwealth of Pennsylvania, by at least $4.5 billion, and that's a conservative estimate for reasons I could spend a lot of time on. So what does it mean when federal funds are under attack? Adam mentioned the biggest source of federal funding is Title I. Title I is a funding formula. It's actually, I think, 4 different funding formulas that govern distribution of funds to schools for either the amount of kids they have in poverty or the concentration of kids they have in poverty. And Adam mentioned it's about $18 billion nationwide. In the Commonwealth of Pennsylvania, it's about $750 million. So again, we're $4.5 billion underfunded. already incorporating that, assuming that we're going to keep that $750 million. For the school district of Philadelphia alone, it's about $170 million. In Title I reports, states, school districts have to say how they're spending the money. Who are the teachers they're literally employing? I think statewide, in Title I and other similar formula-based funding, there are 12,000 teachers funded by federal programs. In the school district of Philadelphia, there are 1,450 teachers that go to work every day funded by Title I. In some schools in Philadelphia, it's 20 teachers in a single school are funded directly by Title I. And that 1,450 doesn't count charter schools, which get their own direct funds. So it's probably in the range of about 2,500 teachers just within the city of Philadelphia educating Philadelphia students due to federal funds. There are a lot of other federal sources of funds. There's Title II, which is professional development of teachers. These are much smaller pots of money, but of course they matter. There's Title III, which is a real target because it funds English language acquisition. Who would ever want kids to learn English? I thought that was in some ways a shared goal. But right after the new administration took over, Russell Voigt sent a letter saying, this is teaching bilingual education. So it thus is some crazy ideology. As someone who has their child in a bilingual in a bilingual education school, he didn't mention that bilingual education is probably the best way to actually help kids that are learning English. But anyway, and then the other big source of funding is IDEA funding to states for children with disabilities. When that law was passed, or predecessor law that was passed in the 1970s, Congress's stated goal was to fund 40% of the cost for kids with disabilities. Right now, we spend in the Commonwealth about $7.5 billion on educating kids with disabilities, and the federal government pays about 8%. But it's still critical, right? It's hundreds of millions of dollars that we desperately need because, again, our schools are desperately underfunded right now by billions of dollars. When I talk about all of this and go to press conferences or whatever, when there's various attacks on the Department of Education or these threats to school funding, I think it's just really important to say, though, that those are all federal laws, right? Done with calculations and that are done in statute, right? And so I feel like in a lot of this, just like when we have to go and put our hands up and say we're going to uphold the rule of law outside of City Hall, we need to sort of get back to the schoolhouse rock. Like, this is legislation, and an EO and a tweet can't undo that, right? So those laws continue to exist. Now, they're under attack right now, right? So Adam talked about the threats to all of this funding, right? We're just going to block grant it all into it. We're going to cut it by a lot, and we're going to block grant it all. That impacts every school district in the entire Commonwealth of Pennsylvania. Whatever the political party is of that congressperson, their schools are impacted. There is, I don't think, a single school district in the Commonwealth of Pennsylvania that doesn't receive Title I funds, and certainly that doesn't receive funding for kids with disabilities. So, we as lawyers like to be the heroes, but I think we can't leave this to the lawyers, because the lawyers will fight about the illegal dismantling of the Department of Public Education, or the Department of Education. But why it's illegal is because we have that legislation there. We have appropriations for Congress that demand things get done. We have a law that says we must have an Office of Civil Rights at the United States Department of Education. We better hold on to all of that. And so outside of the courtroom, we all need to do our jobs and ensure that the people with power understand that it is a bipartisan imperative to stand up for the children of this Commonwealth and this country.
And while you have the mic, Dan, are there any opportunities for the audience or anybody watching to get involved and get engaged in the fight for fair funding in Pennsylvania? Anything happening?
Yeah. Well, you have the mic is familiar a familiar refrain because I don't like to give it up. So
Kathy told me we're on a strict timeline.
yeah.
I will cut you
So
off.
all right. So in the Commonwealth of Pennsylvania, like last year, the state started implementing a remedy to our school funding litigation. It's too slow, it's conservative, but it's also transformative if it ever comes to fruition, implementing those funding, that $4.5 billion of state funding that the state itself now admits that our school districts need. Again, $1.25 billion just in Philadelphia. Whether that we get into year 2 of that plan is going to in part be dependent on what the legislature, the General Assembly, and the Commonwealth does this year. So there are a number of groups mobilizing to try to make that happen. The umbrella coalition that our organization, Deborah's organization, are a part of is PA Schools Work. So if you go to their website, you can sign up, you can go to Harrisburg, you can lobby, do all those things to ensure that the next round of that funding and more goes through. There are also folks doing, like at Children First, for example, another critical partner in this work, doing federal work to talk to their Congress people. You know, if you, for example, live in Bucks County, let's say, there might be a congressperson who should hear from you. If you live in Lehigh County, there might be a congressperson who should hear from you. So there are both state and federal efforts to ensure, going on right now to ensure that our elected representatives do what they're supposed to do.
I wanted to add something about funding. The cuts that have already happened, which have not been to Title I funds, but federal grant programs, these are other sort of pots of money, but federal grant programs for various initiatives have already had an impact on schools. So for example, teacher training programs have been canceled. I was a couple of months ago at a disability conference, a learning disability conference, and I was talking to another speaker there who trains school psychologists. And she's been told to pause her work by the US Department of Ed because her work might be considered to be DEI. All she's doing is training more school psychologists, right? So that we can have an adequate number of school psychologists. And to give you a sense of what that looks like in a place like Pennsylvania, the National Association of School Psychologists, the Professional Association of School Psychologists, recommends that there be 500, no more than 500 students per school psychologist, which actually feels kind of like a lot already. But in Pennsylvania, we're between 1,000 and 1,500 students per school psychologist. So imagine a federal grant program that would help train more school psychologists. That can only be a win for every child in every school. But those are the kinds of programs that have already been cut, you know, as a part of the government efficiency and the anti-DEI sort of initiatives.
I mean, they're going after AmeriCorps, right?
Yeah.
City Year, the programs that send 19-year-olds who want to do service for a
For cheap.
small stipend. They go in and help kids learn to read and do other things. They're going after like any investment in the institutions that bind us together. It's just demonstrated cruelty.
But I mean, I think it's important that the public understand that and speak to that as well, because I think that the administration has really put out such a barrage of sort of misinformation and bizarre information that, you know, the point is that a broad range of young people and families are hurt by this in some way or another.
Yes, and I think it's critical to underscore that, again, federal law and state law still exists.
Right.
And so the US Constitution, Title VI, other federal laws, state laws, the Pennsylvania Human Relations Act, which you'll hear more about, all still exist to prohibit discrimination. And I know what we keep telling school districts and others is don't capitulate. Like these executive orders that say scary things and harmful things don't replace federal and state law and the related obligations and responsibilities to our students and our schools here in Pennsylvania and beyond. And I think that's critical, and you'll hear more about that in the specific context of students with disabilities, but for other students too, and around race and gender discrimination. Like a nasty Dear Colleague letter doesn't undo the existence of the laws that exist to protect our students. So like, remember that.
And I'll note that FOIA also exists as well. So
Say more.
at OCR, there are multiple ways we can resolve or close a case. We have dismissals, and there's various forms of dismissals, and then we have resolution agreements. We may have rapid resolution. We have mediations. And all of this is in our case processing manual. You can see the different ways we can close cases. I imagine that over this next year, you will see the administration will say, well, look, we're closing cases at the same rate or close to it because they will be focusing on dismissals. And these dismissals may come in various forms. Sometimes it's a lack of consent. Sometimes it's insufficient evidence. You know, areas where attorneys or investigators before, if they had more time, if they had less cases, they could do a little bit more digging. I bet you will find that these closures will be disproportionately dismissals, and they won't be through any sort of closure. So they call them closure with change. So basically, you're closing the case, but the school or the district has agreed to make some sort of change to address the situation, which is what the office is designed for. I imagine you will see if you FOIA, and you would want to FOIA, you can FOIA the front office, but the remaining offices themselves directly, because folks are still trying to do that work. So FOIA still exists, and the government is still obligated to provide you with some type of information if you FOIA them properly. And Dan wants to add.
Oh, no. I just said FOIA away.
Okay.
And then Mike will tell us what we should FOIA. I just want to say, like, I think that like the your yes and about we still have laws, your reminder that we still have FOIA, we still have all these institutions. I think it's important just to say that people believe in public education. You look at any poll, people believe in public education. People generally believe in their own public schools. And so not only are those public schools under attack, but in the I'm not going to say what the name for that bill that just passed, but in that large, terrible bill that just passed, while Congress is in another bill contemplating massive billions of dollars worth of cuts to Title I, they put in a voucher proposal, which is largely a tax avoidance scheme that would create a voucher program for across the country up to $5 billion. So again, like we all have to stand up for these institutions that people believe in, because they're not just seeking to attack those institutions, they're also seeking to use private schools to begin to hit the underpinnings of the public school system.
Well, I want to be respectful of time, and Kathy's given me the look. But we
That
could.
clock is fast, by the way.
That one's fast.
Just,
Do
just
you wanna take a couple questions? Guess we should have talked about this before, but
Sure.
we didn't. Take a couple questions.
Questions from anybody?
Go ahead.
back there.
Dan, could you say again the name of the umbrella organization supporting funding in Pennsylvania schools?
Yeah. So the question was, can I say that the umbrella organization supporting Pennsylvania Public Schools. It's PA Schools Work, paschoolswork.org. It is a coalition of groups across the Commonwealth, including the Education Law Center, the Public Interest Law Center, and a number of other Philadelphia organizations, as well as other regions of the state, statewide organizations as well.
15 seconds.
Harold wants 15 seconds.
15 seconds. I mean, one of the things that folks should know is that education, public education is an area in which there's been a lot of research. So we know a lot about what works, what doesn't work, what can work under what circumstances. And I think that one of the tasks of some of at least the advocates and researchers today is to summarize what we know and to put that out to the public as sort of a counter narrative to what the administration is putting out. But there's actually been quite a lot. And I was thinking about this issue of school discipline and the school discipline guidance. There's been so much research on school discipline in the last 5 years, much less say 10 years, that we know a lot about what does and what doesn't work and what makes it work. And I think we really have to, develop those summaries as well, and to put that kind of information out into fact sheets and other things, as Adam suggested, for the guidances that are disappearing almost every day,
Any other questions?
and to the media to explain it.
Okay. Thank you so much to this wonderful panel. With a name like Katayun Jaffari, and coming in as a first generation American with parents from the Middle East, it is because of the public school system in Philadelphia that I can stand before you as Chancellor of the Philadelphia Bar Association. And I truly believe that in my heart. So you probably saw me tearing as you were speaking. As we change our panels, we are bringing up the wonderful Darlene Martin to moderate our next panel, and the panelists to join us on the stage.
Good afternoon. My name is Darlene Hammerker Martin. I am a hearing examiner at the Pennsylvania Human Relations Commission, and I'm also a co-chair of the Legal Rights of Persons with Disabilities Committee here at the Philadelphia Bar Association, and it is my privilege to be the moderator for this second panel, which is a closer look at the impact of the federal actions on students with disabilities. I am going to pass it to Desireé Chang to introduce herself.
Thank you. Good afternoon, everyone. My name is Desireé Chang. I am Director of Education and Outreach with the Pennsylvania Human Relations Commission.
And good afternoon, everyone. My name is Mark Bergman. I'm an associate at the law firm Whistler Pearlstein in the Special Education Practice Group, representing charter schools in Philadelphia, assisting with Philadelphia School District, as well as school districts throughout and other educational entities throughout the Philadelphia suburbs.
Good afternoon. My name is Margie Wakelin. I'm a senior attorney at the Education Law Center, and the majority of my work focuses on representing students with disabilities in both direct individual representation and systemic action and policy advocacy. But I also do other work as including work on behalf of ensuring fair funding here in Pennsylvania. So I'm excited to be here to talk about this important topic.
Thank you all so much. For those who have joined us for the entire day, we've talked a bit about some of the executive orders and how they've impacted all students. But we're going to focus specifically now on students with disabilities. Before we do that and talk about the executive orders, I want to lay the groundwork, particularly for the non-lawyers in the room, and talk about what are the relevant laws that exist for students with the protect the rights of students with disabilities, both on the federal and state level. So Margie, I'm going to turn it over to you first to talk about the federal laws.
Great. So there are several laws that are in effect from federal laws that protect and entitle students with disabilities in our schools here in Pennsylvania and across the nation. So the key one that you've already heard mentioned several times in the last panel is the Individuals with Disabilities Education Act. And that, the IDEA is what we call it. And that is a law that entitles all eligible students, students with disabilities, where their disability has an impact on their education. It entitles them to a free, appropriate public education in the least restrictive environment. And that's really the law that we think of as defining what is special education in our schools. And that is the law that was passed as Dan said in the last panel, Congress enacted its predecessor in the 70s and said to the states, we will provide this funding to you if you comply with this law. And it's never been enough funding that has been provided. It hasn't been what they said that they would provide, and it hasn't been sufficient, but it is a significant amount of funding that if we were to lose here in Pennsylvania, it would be devastating to our students in our schools. So the IDEA is understanding how funding creates the entitlement for students is very important. So that's one federal law that we have. And then the, I would say, companion and oftentimes thought of collectively is Section 504 of the Rehabilitation Act and also the Americans with Disabilities Act. So both Section 504 and the ADA are laws that are anti-discrimination statutes that protect students, eligible students, individuals with disabilities who are in our schools from discrimination. And that may be, as Mike explained, that may be because they're not having access to extracurricular activities because of their disability. It may be that they're not having, they're not receiving the education that they're entitled to. They're not having access to classrooms. They're not having access to programs that are, selective schools, part of their public school because of their disability. So there's a wide range of ways that discrimination can occur in our schools. It also can be discrimination, harassment on the basis of disability. And these are the laws working together. I describe to people that Section 504 and the ADA, Section 504 and the ADA are companions and often understood together. There's Title II of the ADA. That is the title that applies in our public schools. But those, you can think of that as a big circle that includes all students with disabilities. And almost you can understand a concentric circle that is the IDEA. So those students who are eligible. So almost every student, and I would struggle to understand who qualifies for an IEP under the IDEA is also eligible for the anti-discrimination protections of the ADA and Section 504. So these are laws that create education in our schools for students with disabilities, but also impact our schools to ensure that they are inclusive and affirming for all students, and just have become a part in an integral part of the fabric of education throughout our nation.
Thank you so much. And Desiree, we'll turn to you for the state laws.
Sure. I don't know if this is, I don't tend to talk very loud. So, so we have two laws in the Commonwealth that gives our agency, the PA Human Relations Commission, the authority to do what we do. We have the Pennsylvania Human Relations Act. It's a broader anti-discrimination law. It covers anti-discrimination in 5 sectors: employment, public accommodation, commercial property, housing, and education. And then we have the Pennsylvania Fair Educational Opportunities Act, which is more narrowly defined. The scope is specifically education. There's a couple things to note. So as the agency, as a commission, we tend to adjudicate education cases K through 12 under the PHRA because the remedies are more substantial for the victims of discrimination, specifically the students, where the PFEOA is does not afford very much with regards to remedy to students. It really is limited to just a changing educational landscape, given the supports that they need following IEP recommendations, so on and so forth. So as a commission, we tend to approach everything K through 12 with the protections under the PHRA. Post-secondary and VOTEC would fall under the PFEOA. The one thing also to note is that as a commission, and while both of those laws are designed for anti-discrimination, there are some caveats and exclusions. So districts or schools specifically that are considered distinctly private, those do not fall under the jurisdiction of the commission. And that's important to note for several reasons. And I don't want to take more time than what I'm supposed to have, but it was touched on previously with the panel previously a little bit about intersectionality. And I think that we would be remiss if we didn't recognize that. Students with disabilities oftentimes have other types of marginalized, minoritized identities within their being. And so some of the disparate outcomes that we're seeing with students with disabilities are even more egregious and even more pervasive when you take into consideration the idea of marginalized, minoritized identities, specifically Black and Brown identities. We have districts within our schools in Pennsylvania right now that have 100% of their student population that fall under the school to prison pipeline vulnerable populations. Those are students with disabilities, more specifically students with mental health disabilities, Black and Brown students, and students with poverty backgrounds. There's a district that is a stone throws away from here that has over 2,000 and actually over 2,200 students, where 100% of their student population falls into the school to prison pipeline. And so one of the previous panelists mentioned the restoring common sense discipline practices. That's the EO name. It's, we're genius. But basically what it is directing educators to do is disregard that breadth of research that shows and indicates these disparities in discipline practices, and says to disregard those and go back to common sense disciplinary practices, despite the fact that the research says that many educators are not educating populations that are reflective of them, and that they are disciplining with their biases in action. And so the EOs are particularly concerning for students with disabilities because they are one of the vulnerable populations, not taking into consideration the idea of intersectionality. Sorry, I went off, but
That's fantastic. Thank you. Mark, I want to turn to you, and I want you to tell us all sort of what does the Department of Ed do for school districts? Like, what is the impact if this EO about dismantling the Department of Ed happens? How will that impact school districts specifically?
Well, I think the two themes, if I had to boil it down for this, would be funding and regulation or guidance. And the Department of Education provides a significant portion of funding for districts who have this mandate. you have to provide a free and appropriate public education. And for that individual student, based on data, we look actually at evaluations with well-trained school psychologists, which if we don't have enough, backs up the timeline for that. And we still have these duties because they're statutory. We receive the funding, it's there, we have to deliver it. But if we don't have the funding to do it, it's not an excuse for us to say, well, we didn't have the funds, so we couldn't provide that teacher. We couldn't provide that specialized classroom that your child needs. We couldn't do a whole school positive behavior support program that would provide equity in how we approach behavior modification, which is an accepted, absolutely accepted practice and has been for, I don't know how, I can't tell you how long. And then the other part is the guidance, because my role right now, and when I was accepting to be on this panel, I was like, one of these things is not like the other. I am not in public interest or government currently, though I was an intern at ELC and OCR, and was a public school teacher in Philadelphia. So, but it's advising clients on what do we do? What do we do? And right now, more than ever, it is what is happening? What is happening? That's the question we're getting. And what we are telling all of our clients is nothing has changed. Stay the course, to borrow a phrase that now seems so antiquated. Stay the course. You need to continue to follow the law. You need to continue to apply this. It may get more difficult, but you need to do this, and this is how we can do this. So right now, we are just in the midst of a lot of uncertainty more than ever about what will funding look like and what will be the guidance, because for some districts, they have done great work and schools to move forward with DEI for inclusion. They've done great work as a district to move forward. And now I think there is some legitimate fear of facing a small group within districts, whether they are parents or just tax-paying citizens, who are going to make complaints under this administration to try to reverse what the majority of that community and district want, and that they're going to be under attack for that. So I think that's where a lot of the fear is for our clients.
And I just wanted to say that it was very intentional to have you here because we know that this has to be a collaboration between districts, between public interest attorneys, between government. It has to be all of us in this together. So I do appreciate your response. And Margaret, I want to turn to you and talk about the Department of Ed and what you see as the biggest impact if the Department of Ed is dismantled or with the large reduction in force at the Department of Ed.
Well, the biggest impact, that's hard to say exactly because there's so many different ways that the U.S. Department of Education influences what is happening in our schools, particularly for students with disabilities. Mark touched on funding and guidance. And guidance, it really cannot be overstated how important the federal guidance has been, particularly at moments of really great uncertainty in our country. For example, when all schools were forced to shut down because of the COVID pandemic, and really we had so many scared families for their health, understandably, but also particularly for their students with disabilities, what was going to happen for their education. And almost immediately, the U.S. Department of Education started issuing guidance and saying that this education, the expectations for education clearly in terms of what is happening, where our students are being educated, that has changed. But in terms of those expectations that we have that children with disabilities will continue to receive a free, appropriate public education, that kind of guidance coming out was so important. And then our Pennsylvania Department of Education took that guidance and also showed great leadership in issuing guidance to consistent. And they consistently said, we are looking to what the federal government is saying, and then looking for to issue guidance to our local districts. And that was was so important and so assuring to our families, and really that commitment. So guidance is so important, but then there's also, we heard from a former employee of the Office of Civil Rights, and knowing how that office has been decimated, is something that actually keeps me up at night, and makes me get teary-eyed. As of January of this year, 2025, there were 123 investigations of disability discrimination that were happening in schools here in Pennsylvania that were pending. And 86 of those were in elementary and secondary schools. And those were pending then, and probably are pending now. And what does that look like? So just to give you a sense of what, we don't know the facts of all those. We could, FOIA to find out what happens to those cases that are closed, but we don't know. But to give you an example, of the type of disability discrimination cases that OCR is hearing in Pennsylvania. So one in a district outside of Pittsburgh, I think it was November of 2023, they issued the Department of Education issued I want to be precise about this in terms of, I think, reach a resolution agreement. But what had occurred is that over a period of 6 months, classmates repeatedly directed disability slurs at the student and both physically attacked the student and threatened to attack him in a manner directly related to his disability, all of which the student's parent and school staff reported to a district principal. And one of the attacks was captured on school security camera video, and still the principal did not treat it as disability-based harassment. So this clearly, over a period of 6 months, this is pervasive harassment that would be life-changing for this individual student, but also the fact that that kind of culture is allowed to exist within this school impacts, and in that district impacts all of those students. So the inability of OCR now, I was looking at some data where already, I think Mike said this, already caseloads were incredibly high in declarations that were submitted in Carter v. United States, which is the case that is challenging the decimation of OCR. Caseloads were, prior to the executive order and the layoffs, were at 50, around 50 per investigator. And that already was way too high. And now caseloads are estimated at over 100 per investigator. And so what does that mean? That means that the disability harassment that we know is unfortunately occurring here in Pennsylvania is not being investigated the way it promptly, and that 6 months could become a year, could become 2 years, and that we can't get that time back for that child nor for that school. So it's the decimation that is occurring is going to have long-term impact already, and so I think that these are so significant.
If I can just dovetail off of what you had mentioned, Margie. So I don't think I did a great job of introducing our agency either. So the PHRC is the state's equivalent to what OCR was, for those that are unfamiliar. So we are this anti-discrimination, we're the civil rights agency for the Commonwealth. I just want to make note that not every state has a human relations commission or a civil rights commission. There are states, and in fact, one of the plaintiffs in the Carter case hails from a state that doesn't have a civil rights agency. And so they had an active complaint that's now paused with no idea if and when it will resume. So we are fortunate enough to have our commission, but I'll be very transparent and tell you that our commission is a full complement of 92. That includes, it's not just our investigative teams. That includes our senior leadership team. And so our investigators are probably a third of that. No, 2/3 of that, maybe a little more. We span the entire Commonwealth. Our caseloads are minimum 100 to 125 per investigator. So just to put that into context, talking about being underfunded and being understaffed, our agency is not precluded from that. But with that, our total volume of cases is about 300 per month, and out of those full cases for the entire Commonwealth, less than 8% are education related. Our agency has been in existence for 70 years, 70 years, and 8% are education. And so I would encourage everyone to become more familiar with the PHRC and to share the information of the PHRC with your colleagues and within your communities, because there is still a commission that can protect the rights with our two laws that give us the jurisdiction to do that. But also, I want to make note that, to your point, Margie, you mentioned before this current administration, but even now, just in general, Americans tend to look to the federal government for guidance, right? And I think that that's part of the reason why, quite frankly, the PHRC was overlooked as it relates to filing complaints. The two most prevalent types of cases are, in fact, disability, which was reigned true for OCR, and my colleague here can correct me if I'm wrong, but I believe it was disability-related complaints as well as race or ethnicity, and that's also true at our agency. But what we're also seeing is that districts that have a similar agenda, if you will, to the current administration are using the guidances as a means to continue to allow for their environments to be discriminatory. I also follow a lot of the cases, even more so state related. And there was a case within earlier this year where a student with disability, autism spectrum disorder, diagnosis, nonverbal, was being disciplined in an exclusionary practice, which is very common for the students, because again, the teachers that sign up to be teachers don't want to teach students with disabilities. And so he was being removed from the classroom at such a rate that he had not received the appropriate instruction hours to advance up through no fault of his own. But that was a decision made by the educator. Similarly, there was a student that was being made fun of not by his peers and classmates, but by the special education teacher and the TA. And it was reported several times to the administration, to the superintendent and the principal, and nothing was done for that entire school year. So when we talk about trauma and we talk about harms, you can't undo that. And then I'll end with this. Similar to, there are districts that are intending to use the administration to continue to stifle the education of particular students. We have districts that have evolved in their demographics from 20% Latino to 86% Latino, and not one educator, not one, is employed to teach ESL or part of the board, despite the fact that the community at large is 86% Latino. And so those that have been there are intentionally and deliberately not putting individuals, adults specifically, that are reflective of the student population with the intention to make decisions to support those students in seats that they can make those decisions. And so the EOs are also being used to advance very discriminatory and egregious environments as well.
I want to take a moment and see if you all have any thoughts, or I think you haven't given us a lot of things to think about, but if you had some additional advice or action steps that you could suggest for the audience.
Well, I'll start just to say one thing I always like to remind people when we're talking about students with disabilities is to understand that they are also students who are part of the general education setting. So in my introduction, I said that I am someone who has advocated for, continuing to advocate for fair funding for our schools in Pennsylvania. So our schools don't work for students with disabilities if they are not adequately funded. And right now they are woefully underfunded, as you heard. And the cuts, not just to special education funding, the IDEA, the $240 million that Pennsylvania alone gets for students with disabilities, that would be devastating. But as Desireé said, the intersectionality that our students with disabilities face, our students with disabilities are also experiencing poverty, and many experiencing deep poverty. They're also English learners who need Title III funding. They are also our students who need Title I funding. They need reading interventions that are paid, and counselors that are paid for by Title I funds. So an action step, I would say, another, just to make sure that I think I was a former public school teacher as well. And I know the importance of repetition and making sure that you hear messages multiple times. So to reach out to learn more about PA Schools work and the work that's being done in Pennsylvania, in Philadelphia, to advocate for fair funds for our schools. We have, we want you to know what is happening at the federal level in terms of the decimation, but there's so much work that needs to be done also here in Pennsylvania. So learning more about that, and also the Education Law Center, our website has as many different resources about, I think, more than 50 fact sheets on various areas of education law, including many on the rights of students with disabilities, but all of the other underserved populations that we've talked about today have important rights that need to be upheld, and lawyers are so important to that.
I would share to help educate the public and making yourself aware, but to help put out there in messaging. I think it's been brought up. There's a lot that can be done to help teach, to help advocate, to spread that message, because of the Orwellian doublespeak that comes through much of this, including the fact that there are people, as it's already stated, who like public education. In their mind, they might not see this as it's going to affect them or their kid, but it is, and it's going to affect their whole community, because public education is a bedrock for American democracy and our entire system. So with some of that in mind, I just wanted to pull two things that I think really need to be, like, when you look at it and hear it, and it's something that we can do as lawyers to better understand what's really being said and happening, and then to educate the public. But from the skinny budget, with breaking down the brief description of the recommended flatline, no increase to special education funding, in the final two sentences, parents of students with disabilities would remain empowered to direct these funds because the federal IDEA would remain in place. Maintaining a base set of federal funds means they can also be withdrawn from states and districts who flout parental rights. We have heard, I'll tell you on my side, we've heard from opposing sides, well, it's my tax dollars, I should just be able to take it to go to this private school for my child, because that'll be best with them. And it's staying calm and composed during those moments. But the other would be from just 1 week ago, when McMahon gave a report to the Appropriations Committee subcommittee, and in that letter explained that these reforms to OCR have enabled us to stay on pace with past administrations in our processing of civil rights complaints, including disability complaints, with a leaner OCR staff. Because if you don't have the data, and if you can just mark it closed, we're keeping pace. We're doing better than ever with less money. And until the public understands what it really means, what they're hearing is same results, less taxes, but it's actually hurting everyone in their community, and making them understand that in simplified terms is the best I think we can do.
I want to just ask a question before we move to you, Desireé. When you talk about public education, can you just, for the audience, talk about like which schools specifically? Does that include charter schools? Does that?
Yes, as the Supreme Court said a week ago. It was quite a day with all the decisions in flurry coming down. But well, at least they deadlocked. They didn't really say much, but it's charter schools. They receive public funding. They also have to implement these laws when they get that public funding. Charter education is the only increase in the budget. It's also seen as one of the 3 priorities over returning to the states, but also parent choice, and that we should look to innovative models. We represent charters. There are a lot of innovative models. There are different needs for different kids than maybe the traditional public school. That goes for students with disabilities. That goes for students on any different area. But it's public education, and it's supposed to go to help the entire public as a public good, not as just a benefit. So,
Thank you.
I'll just use my final moments to put a shameless plug to support the PHRC in your various capacities and abilities. There have been, for several years, attempts to remove our independence. We are considered an independent agency, which give us the ability to do what we do. I know it was shared just at last week's ELCPA's Lunch and Learn that a state that was formerly independent was moved under their AG's office that has been historically hostile towards civil rights. And so it's incredibly important in today's day and age that the PHRC remain independent so that we can do things like interpret our regulatory language to be more broad and cover protections for students like we did in 2023. Had we not had our independence, we may not have had the ability to do that. So I would shameless plug that, and then also, follow to what one of my colleagues had mentioned. Forgive me, there's so much swirling around in my head. Is also to just be aware what's happening within your communities, what your legislators are putting out. There is a particular legislator that is mimicking Project 2025 to a T. Whatever comes out from the federal administration within 2 weeks, we see it come out by that legislator here in PA. But they're also the good news, because I know we have been a very dark panel, I'm sorry, is that there are, though, some bills being proposed. Romans law, there's also HB 2028 that's looking to bring broader protections and disability related curriculum here in PA. So, we are fortunate enough to have the governor that we have and the agency that we have, and you all have, to be able to continue to fight against what is happening above us. But we need more manpower at our agency.
I want to take a few minutes and see if there's any audience questions or questions. I don't know if online participants could also ask questions, but I just didn't know if we had any.
Hi, I just want to thank you all for your service. We really appreciate you in this room. I have a question for our PHRC panelists. So in Philadelphia, you only get a jury trial on a discrimination case in federal court. You get a bench trial under the PHRA, as you know. Do you believe, because federal juries are non-diverse, are suburban, therefore generally less liberal, that the creation of the right to a jury trial under the Philadelphia Fair Practices Ordinance would create a light at the end of the tunnel and trickle down justice through your agency to see more discrimination victims obtaining favorable results? Do you think that that would be a good thing?
So I can speak a little bit as one of the hearing examiners at the Pennsylvania Human Relations Commission. So I would be one of the people that could hear a case. And just for knowledge, we as hearing examiners provide recommendations to the commissioners, but ultimately any decision has to be voted on by the commissioners. So we, as you know, interpret the Pennsylvania Human Relations Act and not the Philadelphia I know there is a separate Human Relations Act in Philadelphia, so I was unaware of any sort of potential provision to allow jury trials, and can't really speak to whether that would allow for fairer results. But I just want to echo Director Chang's point, Desiree's point, that I think it's really about making sure that agencies that do this work, whether it's specific to Philadelphia or Pennsylvania Human Relations Commission, have the staff that they need to investigate properly and to really, consider the discrimination that may have taken place.
Thank you. Do you need more mediators in the PHRC?
So from my understanding, the mediation division is soliciting volunteer mediators. So if you're interested, one more shameless plug, we are looking for a chief counsel. And also just, I don't want to forget to mention that our newest Protection for Education trifold, I did bring a stack up here in the corner. Help yourself.
No plug is shameless. We're here to learn, and we're here to have opportunities provided to us. So keep them coming.
And before we get to the next question, I just wanted to remind folks that while Desireé is here speaking specifically about students with disabilities, the PHRA's protections are much broader, and that our website includes fact sheets for all kinds of all the different protections, and is really laid out in such a way that non-lawyers can understand, because people who come to our agency don't have to be represented. If after the investigation probable cause is found, then you can be represented by a commissioned attorney free of charge. They represent the Commonwealth's interest in the complaint, but they do also work with the complainants. And so I just wanted to also remind folks that the PHRC has a lot of fact sheets and is free to the public.
My question is for Mark. Do you find charter schools understand their roles and obligations under federal civil rights law? And if not, what tend to be the blind spots?
So, as their legal counsel, I I think that it's more, and it's part of on us to help them understand that, because I think where a lot of charters come from, in my mind, it can really fall under two ways. There's the charters that are sort of part of the system, that have numerous schools. They may be even in multiple cities, and they're organized this way. And they're a bit more sophisticated with their organization as well as their legal counsel and representation. And they have a better understanding and see themselves more as public. But then you have the other charters that are one or two locations in one city, and they actually are more novel in their approach to what their mission is. And those are more community-based and driven. And I think that they do see themselves as separate for that reason and as distinct. And so their understanding of the impact of what their role is or what they have to do is very different. And I will just say that it's, we get a lot of questions, we provide a lot of guidance, and we're often telling them, like, yes, do that, like, in a positive way. So I hope that was an acceptable answer.
And I'll just say, as someone who represents families and students, that the need for legal counsel and guidance spans all types of public schools. So it's not just charter schools, but also our school districts that benefit from the guidance that's been provided at the federal level that clarifies their obligations under the law. So, but charter schools are certainly obligated to follow those laws, both the federal and many of the Pennsylvania laws, although not all, and that's curious. So that our traditional public schools need to follow.
Hi, thanks to you all for your time today and to the prior panelists as well. I have a question about the PHRC caseload. We heard some numbers about how many people you have on staff and what the caseload is, which does sound daunting. Um, Question is whether that represents an uptick. Has there been an influx of more complaints and referrals ever since OCR has become less available and people in Pennsylvania are looking to PHRC to fill a gap?
Not yet, but we do anticipate there to be an influx. We're not seeing it yet. It seems to be like an odd delay. I think people pause hoping that it's maybe not going to be as bad as what it is, and then wait and then do some research and that. But our jurisdiction is our timeliness is 180 days from the act of harm. So those that had newly filed OCR complaints, I know they've been encouraged to come to the PHRC to see if their complaint is jurisdictional under us.
Um, Following up on that, so uh, I assume it's still the case that the PHRC is funded in significant part from the federal government, whether it's in employment cases or housing cases and the like. And the federal government, I think fairly recently, has said they're not going to consider, for example, disparate impact cases, and they're not going to reimburse states for disparate impact cases. How does that kind of guidance influence how the PHRC prosecutes cases?
Well, two things. We no longer have a work share agreement with HUD. We closed that agreement 2 years ago now. We do still have a work share agreement with EEOC. But as far as the disparate impact, I believe our legal is kind of analyzing it and assessing it to determine, because our act does dictate that we interpret our law liberally. And disparate impact is still very much a theory under our law, and that hasn't changed. So how that plays out in reimbursement, that's above me.
Yeah, I'm gonna thank you all for being panelists, and thank you all for attending, and turn it back to the Bar Association and Vic.
Thank you, everyone. For those of you who don't know me, my name is Vic Patel, and I have the honor of serving as the chair of the Board of Governors, and also spent a little bit of time teaching in public school before I was an attorney. First, thank you to all the speakers. Thank you to the moderators. Thank you to the organizers. Thank you to the staff. You do so much to support us, so thank you for helping us put this together. Thank you to Kathy for your leadership, your continued leadership through these sort of uncertain times, and thank you to all of you for joining us. Our fourth meeting the moment, focusing on education and disability rights. Access to quality education is what sets us up for the rest of our lives. But as you've heard today, that access is uncertain and under threat. And right now, the stakes are high because, as Michael Athy said, students only get one shot at their education. And as Desireé Chang said, you cannot undo trauma and harm. That is why it is so important for us to come together and stand up for fundamental rights in vulnerable communities. Which is why we're going to continue to have these conversations and come together. And so please watch out for 2 upcoming programs. We have 2 meeting the moments. First one is going to be on June 26th. That's going to be a focus on the rule of law. And the second is on July 16th, a focus on diversity, equity, and inclusion. Now, thank you all for joining us once again. This is such a great supporting community to be a part of in these times. And we hope to see you all soon.